Hi, I'm Jason Rosenblum. I'm an intellectual property attorney, and in this IP Basics video series, we're talking about some of the building blocks for a successful business from an intellectual property perspective: patents, copyrights, trademarks. In this video, we'll talk about the US trademark process. So in the US, you file your application with the US Patent and Trademark Office. It can be filed electronically, and once it's filed, essentially there's a cursory review for formalities, but the main review happens at about 3 to 4 months these days, actually more like 5 months right now at this time period. We're in May of 2021, and it's about 5 or 6 months that they're looking at applications. And that happens right here, where the examining attorney at the US Patent and Trademark Office reviews it. And there's two things that they're going to do. They're either going to approve it, or they're going to issue an office action, which is a letter with rejections. And when they review it, they look for a number of different potential issues with it. And if they find any of those, they'll issue a office action that has those rejections. It could be anything from just a term is descriptive that you need to disclaim so your competitors can use it as well. If you have the word corp or LLC in your name, or a name that describes the product, such as computer, those you have to disclaim so competitors can use them as well. Bigger issues would be something like likelihood of confusion, that they say that there is another registration that is your trademark application would cause confusion with. And you can put in a written response. You have generally 6 months to respond to those, and if you don't respond, your application will go abandoned, meaning it's dead. But if you respond, then what happens is either you persuaded the examining attorney that they should let yours through and they approve it, or they can issue a final rejection. If they approve it, just like above, if they approve it, it then goes on to publication, which is down here. If your application is published, what happens is it publishes for 30 days for any third party to come along and oppose your registration. This could be because they believe it's too similar to a registration that they own already, too similar to a trademark that they've been using prior to your filing of an application or prior to your use of that trademark, or that they just believe that it's something that's common use in your industry and no one should have protection over it. And an opposition, if someone does file that against you, it's essentially like a mini litigation before the Trademark Trial and Appeal Board. Assuming your application goes through with no issues, then you would receive, in the case of an intent to use application, a notice of allowance at this point. But if it was filed based on use, meaning that you were actually using the brand and selling products under that name, providing services, and filed your specimen at the time of filing, then you would receive what's called your registration. The total process from start to finish in a smooth case is about 12 months. But if you receive an office action, that can add some time to it, as well as sometimes things just move a little bit quicker. I just received one that took 10 months, which is probably one of the fastest ones I've had at this stage right now. If you filed based on intent to use, what's going to happen is you're going to get 6 months from that notice of allowance date to have to file and show how either you're using it in commerce, which is a statement of use, or file for an extension. And you can file potentially 5 of those extensions every 6 months. So you have about 3 years to show use from filing it. Once you file a statement of use, that gets reviewed. The examining attorney looks at it and either approves it, saying you have proper use, or again, they can issue a rejection. If everything's proper, that's when you'll receive your registration certificate. And then at a later date, you'll have to file your renewal applications and your declarations of use to maintain it. And so long as you're using it and willing to pay the fees, you can continue to have that trademark registration. Again, I'm Jason Rosenblum, Law Office of Jason H. Rosenblum, and we're here to help our clients understand intellectual property and help them protect it. If you have any questions, you can reach out to us at 888-666-0062.